You need to stop thinking about contracts as documents. Because if you do think of them as documents, you are missing the point. We're going to talk about what contracts really are and why thinking about contracts as documents or a page that gets signed is a total distraction from the underlying purpose. And when you have the right perspective on what a contract really is, it will help you avoid 90% of the problems that come from bad contracts. Sure, at the end of the day, a contract is going to be a legal document that's signed by both parties and it has a bunch of legal terms in it. But here's the problem. Those contracts are boring and nobody really wants to be dealing with them. And so what often happens is somebody is tasked with the assignment of reading through a legal document provided by another party, maybe negotiating a couple things or tweaking them, and then there's a signature. And that's the wrong approach to putting together a contract. I'm going to walk you through the right approach here as far as if you are the CEO or you are the lead on a project, you're the business owner, let's say, before you have anybody analyze the language of the contract, there's certain questions that you want to think through. And when you do that, it informs every aspect of what should be on that page. So here's the problem. Too many companies are stuck in breach of contract lawsuits or they have other contract problems. For example, has this ever happened to you? You pay for something, but you don't get it. Or you already provided a product or service, but you don't get paid for it. Or you have some disagreement in a contract, and all of a sudden you find out your legal rights were not protected. Or practically speaking, maybe your rights were protected in that contract, but there's no real way to recover the money that you're owed. Maybe the other party's in another country. Maybe it's not worth the legal fees to pursue, but there isn't a practical option to recover what you're owed. And that's why each one of these problems is why we want to step back before even dealing with a document that says contract or agreement on the top. And we want to ask a few initial questions. The questions are based on the purpose of a contract. What is the purpose of a contract? It's quite simply this. Both parties getting their expectations in writing to avoid frustrations down the road. And second, if the other side violates the expectations, giving you the ability to recover your losses. That's really at the heart of what a contract is. So, what questions do we need to ask before working on the document itself? What are your expectations? In other words, what are you hoping to get out of this relationship? Are you getting a product, a service? Are you getting paid for providing a product or service? Maybe it's a partnership where you're both contributing labor and ideas and time. But identifying what is it you hope to get out of this relationship from a non-legal standpoint. Don't get into the legal terminology because that distracts from the business mindset of here's what we want out of the deal. And then also, what is the other party expecting out of the deal? And when you get real clarity on what you want out of the deal and what they want out of the deal, that allows then a lawyer or whoever's working on the document to make sure those expectations are in the document. So that's really step one. What are the expectations both parties have? And then, if those expectations are violated, how can you recover your losses? So that's a practical analysis. Because it's easy to say, well, you breached the contract. Yeah, but then what? Then what does a person do if they are a victim of breach of contract? Do they now have to file in court and spend a year and a half trying to prove that the other side breached a contract, and in the meantime, spend $5, $10, or $15,000 a month on legal fees, that's not a great situation. So making sure that you have leverage beyond just breach of contract is going to be an important practical consideration. You might be saying, well, what does that look like? Well, a lot of times it's getting paid in advance, or saying we're not going to pay until a certain milestone is met. There may be agreement on payments over time based on performance over time, so that one party isn't taking all of the risk of paying in advance, and the other party isn't taking all of the risk of producing work or labor in advance prior to getting paid. There are other options, like collateral or security interest. That's where you put up something in exchange for the promise to make payments. The thing you put up might be real estate. We call that a mortgage on real estate. Or it might be a lien on something. But that's one option. You can also use an escrow service where there's money set aside with a third party. They are holding it in escrow until both sides have performed. That way you at least know the money's there, and you're not having to sue a company for it, because let's face it, many times at the end of a lawsuit, companies don't have any money. Many small businesses go out of business just paying their legal fees. So even if you win a lawsuit against a small business, it may turn out they have no money to actually pay you for the judgment you won in the lawsuit. So an escrow service might be a way to at least make sure that money is set aside in advance for the payments that you're owed. Another option is a confession of judgment. And a confession of judgment is often used with a promissory note. This is an advanced technique, but the general idea is if a person owes a set amount of money and that amount of money isn't paid, you don't actually have to go sue for that money. You just file a confession of judgment. Now, there are restrictions on when this can be used. But the gist of this is we're thinking ahead of time before even talking about the legal document that we're drafting up, the contract or the agreement. And we're thinking about what are the expectations of both sides? What are both sides getting out of the deal? And if one side doesn't do their part, how do at least you have leverage so that you're not stuck without the money or whatever else you were promised? Those are the considerations that go in advance of ever putting together the legal document. When I talk with my clients about drafting a contract, I have a non-legal conversation with them about these topics. I say, setting aside all the legal stuff, just tell me in your own words, what's the benefit to you of this relationship? Why are you going into this deal? What are you hoping to get out of it? And here's another little trick. Ask yourself, if all goes well, what does that look like? And then if all goes bad, what does that look like? And then you think about both scenarios, making sure that you've protected yourself in either extreme hypothetical. Whether it all goes bad or it all goes good, you want to make sure you are protected. Once these pieces are known, then a lawyer or AI can start drafting up a pretty good contract. A lawyer is also going to then think, what are the terms, the standard terms that should be in place in order to protect you in these circumstances? So as you can see, the foundation of a great contract is answering some big picture questions before you actually go and start drafting anything in the contract. Now, of course, there are all sorts of templates out there. I have tens of thousands of templates. The trick is not drafting. AI can draft. Templates are a dime a dozen. You can get them on the internet for free. The key is figuring out which template works for your scenario. In other words, which language is needed to cover the risks and expectations that you have. Now, what are some common problems that I see in contracts? One big one is when a business doesn't use a good lawyer, so they use AI or a template or a lawyer who makes a mistake. The mistake is not what's written in the agreement, it's what's missing from the agreement. In other words, no effort has been made to think about the potential problems or risks and make sure those are covered. That's why it's so important to start with thinking about, from a business standpoint, what are those risks? Once you know the risks, then you can mitigate those risks with appropriate contract language that addresses those scenarios. The next most common mistake is language in a contract that isn't clear. In other words, it could be interpreted two different ways. The legal term for that is ambiguity. In other words, reasonable minds can differ on what a sentence or a term or a paragraph means. That might be because the actual language is just not clear. It may be that a word is susceptible to two different definitions or interpretations, but it also might be that there are conflicting provisions. And judges, when they look at contracts, they need to look at it as a whole, with an assumption that those apparently conflicting provisions should somehow be synthesized so that they can both be given meaning. Well, what does that mean? How does that look? Frankly, that's what lawyers argue about in court. And so avoiding unclear language is a common mistake. Now, often AI doesn't make that mistake. It's often made by humans who go in there and either they add new language to a template, which now causes a conflict with some other section, or misinterprets or raises issues with another section, or it just simply isn't clear enough. Lawyers are trained to be very clear in their language. And often that's why lawyers are using terms that have already been argued about in court, so that those terms have very clear meanings under the law. And those terms are used rather than an unclear term. What's an example? Well, you will often find people saying, if it's a written agreement, it's handled this way, but if it's a verbal agreement, it's handled a different way. Why? Because many people assume verbal means spoken, and written is the opposite. But that's actually not true. Oral means spoken, written means in writing, verbal can be oral or written. So that's a perfect example of where normal, average people who are intelligent, who are educated, might use a word like verbal, not realizing that courts have interpreted that to mean both oral and written. So if you really want to talk about what's spoken, you need to use the word oral. And again, that's just one of many examples on how words can be unclear. The next biggest mistake I see is there's no practical way for a party to enforce their rights. For example, they might be able to prove there's a breach of contract. They might have the ability to recover attorney's fees according to the contract. But practically speaking, if you sue the other side and they pay $150,000 in legal fees, will they even be around? A lot of small businesses won't be. And so practically thinking about, what are we going to do if the other side breaches this agreement? Many times, that means you don't put a whole lot of weight in the language of the agreement. You put weight in holding off payment until you get what you're entitled to under the agreement. Now, you still want the written language of the agreement to protect you in case there's a lawsuit later, but we're trying to make sure that you have the ability to enforce the contract by keeping leverage. You're not giving up all of that leverage and then hoping the legal system somehow will come save the day for you. You need to keep leverage, and money is often that leverage. So let's recap. What are the big questions to ask yourself? What are the expectations you have as far as what you're getting from this relationship? And what is the other side getting from this relationship? If all goes great, what are you getting and what are they getting? If all goes bad, what are you getting and what are they getting? And how are you protected if things do go bad? Are you out money? Are you out time? Because in many cases, assume the legal system will not save you. Do you have some sort of practical leverage in the arrangement? Once you have clarity at least on those pieces, that is then when it makes sense to use some templates selected for these similar scenarios with language that addresses these risks, these expectations, the pieces that you expect to get from the deal, and what you are giving up as part of the deal because the other side is getting it. These are the pieces that make a great contract. So instead of thinking about a contract as a legal document, think about it as, what are you getting? What is the other side getting? And if you don't get what you think you're supposed to get, what are the rights that you'll have and the protections in place practically so that you are protected? That's the way that great attorneys think about contracts when writing it. That's what an exchange looks like with an attorney when you go to draft a contract. And so now you, ahead of time, can be thinking about, what am I getting out of this agreement? What am I giving up? What's the other side getting? What are the risks associated with this? What are the expectations that we have? And then phase 2 is where an attorney or someone else makes sure that all of those terms that are standard in a similar scenario are incorporated into the legal document that you then sign. I'm Aaron Hull. I'm an attorney for business owners and entrepreneurial companies. If you're interested in getting exclusive access to videos like this and other educational content, you can go to aaronhall.com/free. And by going there, you enter your email address and you'll be given through email access to exclusive resources, content to educate you, to help you avoid legal problems and expenses in your company. Again, that's aaronhall.com/free. If you would like more educational content like this to grow your company, to help your company avoid legal trouble and problems from a practical standpoint from an attorney like me, you're welcome to like this video so YouTube algorithm suggests more content like this for you. And you can also subscribe to this channel so you can know when new content comes out. I do these videos so that I can use my knowledge and experience to help you and your company, to help embolden you, give you confidence, give you knowledge, so that you can achieve the success in your company and build a great company for your team.